Okay, today I'm reading once again from the Disability Rights Law Cases and Materials Casebook by Samuel Bagenstos. This is the second edition, and we've advanced to page 560, which includes notes on insurance in the ADA. So there are 3 cases that were part of the insurance section, which is covered in Title III and includes a safe harbor and a caveat to the safe harbor, which would be that the safe harbor, or that insurance policies cannot subterfuge ADA compliance by dressing up the plan to appear to be covered by the safe harbor. So, reading the notes on these 3 cases, which is Doe versus the Mutual of Omaha Insurance Company on page 546. Followed by Leonard F. versus Israel Discount Bank on page 552. And lastly, we covered Seth versus Broward County in Florida on page 558, let's say. We're going to go over notes relating to those cases, starting with 1, the access content distinction, 2, the safe harbor, 3, employee wellness programs, and move into some introductory notes about remedies and standing and pleading requirements as demonstrated in Naaman versus New York University. The access content distinctions, starting on page 560, is Judge Posner's majority problem in Doe employs an access content distinction as the public services context. Application of the access content distinction turns crucially on the level of generality at which the relevant good or service is defined. Judge Posner argues that the plaintiff was not denied access to Mutual of Omaha's goods or services because the company offered to sell him the same insurance policy on the same terms as it would offer to people without AIDS. And under that contract, he contends people without AIDS are not entitled to any service that is denied to people with AIDS. But as in Alexander v. Coate, a principal case in Chapter 4, when the matter is considered at a higher level of generality, it certainly appears discriminatory. Company offers to cover all of the health needs of people without AIDS, but it will not cover all of the health needs of people with AIDS. Indeed, as Judge Evans explains in his dissent, the policy at issue might be understood to be discriminatory even when we consider the question at a low level of generality. When a person without AIDS gets pneumonia, the policy covers it, but when a person with AIDS gets pneumonia, the policy does not necessarily. Does Judge Posner have an adequate answer to that objection? Is the access content aspect of the Doe opinion still good law after PGA Tour versus Martin? Note that the insurance policy at issue in Doe with its lifetime cap would now violate the ACA, which is the Affordable Care Act. The long-term disability policy at issue in Leonard F., which merely replaces lost income, is not a health insurance policy for purposes of the Affordable Care Act and therefore is not subject to its prohibition on lifetime caps. So we went into the Affordable Care Act, which does not allow exclusion waivers for pre-existing conditions or caps such as this lifetime cap at issue in Doe. The safe harbor, section 2, within notes on insurance in the ADA. In Doe, Judge Posner rules for the insurance company without relying on the safe harbor provision. As his majority opinion notes, the company conceded that the safe harbor did not apply. The company presumably made that concession so that it could tee up the broader access content argument that the Seventh Circuit adopted, an argument that will shield insurance companies from liability for plan terms in many cases. In Leonard F. and Boots, however, Boots is not one that we read. The courts reached the safe harbor question. What exactly does the ADA's safe harbor provision cover? By its terms, the safe harbor provision protects risk classification decisions that are based on or not consistent with state law, as long as those decisions are not a subterfuge to evade the purposes of the ADA. To enter the safe harbor, then, an insurance company must comply with state law prohibitions on unfair discrimination, which generally requires an actuarial basis, though precisely how much is a matter of some dispute. Question. Next sentence. But even if the risk classification complies with state law, the insurance company will still be liable if the classification is a subterfuge. What does subterfuge mean in this context? In Doe, Posner suggests a subterfuge would exist if Mutual of Omaha had adopted the AIDS cap to deter people who know they are HIV positive from buying all the policies at all. In Leonard F., Judge Laval reads the subterfuge proviso as reaching only those classifications that are adopted in an effort to evade the purposes of the ADA, specifically, under his interpretation, a risk classification that a company instituted prior to the adoption of the ADA necessarily could not be subterfuge because there was no ADA at the time. What do you find to be the best interpretation of the subterfuge provision and why? Okay, so they gave an example in the case that if the Doe policy didn't allow people with AIDS to get care for like a broken leg, then that could be considered discrimination. And I would say that's because the policy evades the purposes of ADA and intentionally, and that would meet, I think, the proviso, subterfuge proviso, making that policy subject to not subject to the safe harbor. Part 3, employee wellness programs. Workplace wellness programs have become an increasingly popular tool among employers who seek to control their health care costs. See Jill R. Horwitz, Brianna D. King, and John E. DiNardo, Wellness Incentives in the Workplace, Cost Savings Through Cost Shifting to Unhealthy Workers. These programs can take two general forms. One, health contingent wellness programs, which reward or penalize employees who satisfy or fail to satisfy specified health standards. And two, participatory wellness programs, which incentivize employees to participate in health promoting activities, whether through rewards or penalties, as in the program at issue and set, or through subsidizing those activities through discounted gym memberships and the like. Whether these programs, in fact, save healthcare costs is controversial. Compare Catherine Baker, David Cutler, and Zirui Song piece titled Workplace Wellness Programs Can Generate Savings, dated 2010. Finding that medical costs fall by 3.27 for each dollar spent on wellness programs in their book. And with Horace A. Supra, the earlier book that I cited, reviewing evidence suggesting that savings from health contingent programs may not, in fact, derive from health improvement, but rather may derive from making workers with health risks pay more for their health care than workers without health risks do. Not sure I understand that argument. Despite the controversy, the Affordable Care Act loosens various pre-existing restrictions on workplace wellness programs. And we're being referred now to another book called Inside National Health Reform by John McDonough of 2011. The Departments of Treasury, Labor and Health, and Human Services implemented these provisions of the ACA, Affordable Care Act, in a joint regulation. And the citations are here on page 561. The regulation continues to impose significant restrictions on wellness programs. For participatory wellness programs, the regulation requires that any program must be made available to all similarly situated individuals, regardless of health status. So for health contingent wellness programs, the regulation requires that you see 4 bullets here, 4 requirements for health contingent wellness programs. The first being that eligible individuals must have the opportunity to qualify for the program at least once per year. 2, the monetary award for compliance with the program is no more than 30% of the cost of health insurance, an amount that can rise to 50% to the extent that the program is designed to reduce or prevent tobacco use. 3, the program is reasonably designed to promote health or prevent disease, which the regulations define to mean that the program, based on all the relevant facts and circumstances, has a reasonable chance of improving the health of or preventing disease in participating individuals, and is not overly burdensome, is not a subterfuge for discriminating based on a health factor, and is not highly suspect in the method chosen to promote health or prevent disease. And lastly, fourth requirement for health contingent wellness programs is that the full reward is available to all similarly situated individuals. And the citation is provided. To satisfy the last criterion, the program must allow a reasonable alternative standard or waiver of the otherwise applicable standard for obtaining the reward for those persons for whom it is reasonably difficult due to a medical condition or medically inadvisable to satisfy or attempt to satisfy the program's normal criteria. For those health contingent programs that are outcome-based, which the regulation defines as those that require an individual to attain or maintain a regular health outcome, such as not smoking or attaining certain results on biometric screenings, in order to obtain a reward, the citation given, the regulation additionally provides that a reasonable alternative standard to qualify for the reward must be provided to any individual who does not meet the initial standards based on a measurement test or screening that is related to a health factor. These reasonable alternative standard requirements obviously have some, though not perfect, overlap with the ADA concept of reasonable accommodation. Even if a wellness program complies with the ACA requirements, it must comply with the ADA. Compliance with this section is not determinative of compliance with any other state or federal law such as the ADA. Wellness programs might raise a number of questions under the ADA. However, I feel like they're going to meet the safe harbor as long as they're administered in accordance with state law. One set of questions concerns the requirement of reasonable accommodation in employment. If an employer offers a wellness program that subsidizes membership in a gym, but the gym the employer has chosen does not provide accessible exercise equipment, must the employer accommodate an employee with a disability by providing her with a subsidized opportunity to participate in accessible fitness activities? If an employee has a disability that makes her incapable of participating in a participatory wellness program or meeting the standards of a health contingent wellness program, how must the employer modify the terms of the programs to accommodate her disability? And they're citing the EEOC GINA regulation. If an employer offers a financial inducement for participation in disease management programs or other programs that promote healthy lifestyles and or require individuals to meet particular health goals, the employer must make a reasonable accommodation to the extent required by the ADA. That is, the employer must make modifications or adjustments that enable a covered entity's employment as are enjoyed by employee with a disability to enjoy equal benefits and privileges of employment as are enjoyed by the other similarly situated employees without disabilities, unless such covered entity may demonstrate that the accommodation would impose an undue hardship on the operation of its business. And that's quoting a regulation cited here. A second set of questions concerns the ADA's regulation of post-employment medical examinations and inquiries. Recall that Title I of the ADA prohibits employers from requiring a medical examination or making inquiries of an employee as to whether such an employee is an individual with a disability or as the nature or severity of the disability, unless such examination or inquiry shown to be job-related and consistent with business necessity. Citation from ADA. The statute makes an exception to the prohibition for voluntary medical examinations, including voluntary medical histories, which are part of an employee health program. Part of an employee health program available to employees at that work site. The EEOC, Equal Employment Opportunity Commission, has said that a wellness program is voluntary as long as an employer neither requires participation nor penalizes employees who do not participate. EEOC enforcement guidance, disability-related inquiries, and medical examinations of employees under the Americans with Disabilities Act, available at blah, blah, blah. There's a website here for the EEOC.gov-policy docs, guidance inquiries.html. But what constitutes a penalty? When as in SEF, employers give their workers a medical examination and inquiries properly understood as voluntary. Does it matter how large is the financial incentive? Is $10 deducted from an employee's pay each week, as in SEF, sufficient to render the examinations involuntary? The final set of questions concerns the application of the insurance safe harbor. SEF holds that the medical inquiries involved in Broward's wellness plan were entitled to the benefit of a safe harbor because the wellness plan was provided as part of Broward's contract with its health insurance carrier. Participation in the plan was limited to individuals who receive health insurance from that carrier, and Broward's documents describe the wellness program as part of its health insurance plan. Accordingly, the 11th Circuit concluded the wellness plan was a term of a bona fide benefit plan protected by a safe harbor. Is this a proper reading of the safe harbor? Does a wellness program like Broward's underwrite risk, classify risks, or programs like Broward's or administer risks? It certainly does not assign people to different coverage or rates based on their actuarial risks, the sort of conduct that the safe harbor deems designed to protect. Does Seth mean that an employer can avoid ADA review of a wellness program simply by declaring that program will be part of its health insurance benefits plan? Would the subterfuge limitation on safe harbor limit that sort of evasive conduct? Yeah, if you consider the intent to be malicious, but it's kind of hard to say that an employee wellness program is intended to circumvent the purpose of the ADA. Sorry, nice try. It's to benefit the employees. And if there's, it seems to me that to penalize non-participation is probably the path of least resistance, because you're going to get in more trouble for rewarding participation that is successful, because that seems like it's going to be harder to attain for people with disabilities than just penalizing people that don't want to participate. So, Section E, remedies, introductory note. On page 564, the Title III of the ADA may be enforced in two ways. Any person aggrieved by a violation of the statute may file a suit for injunctive but not monetary relief. See 42 U.S.C. 120, Section 12188A, incorporating procedures for enforcement of Title II of the Civil Rights Act of 1964, and another citation by reference. In cases in which the defendant, in quotations, is engaged in a pattern or practice of discrimination in violation of Title III, or in which the claimed discrimination raises an issue of general public importance, the Attorney General may file an enforcement suit as well. Unlike a private party, the Attorney General may seek compensatory monetary damages to persons aggrieved, and civil penalties not exceeding $50,000 for the first violation and $100,000 for each subsequent violation, as well as injunctive relief. Because the Department of Justice has limited resources with which to enforce Title III, private attorneys account for the bulk of enforcement. See generally Samuel Bagenstos text, The Perversity of Limited Civil Rights Remedies, the case of abusive ADA litigation. Under the Fair Housing Act, by contrast, private plaintiffs can recover actual and punitive damages as well as obtaining injunctive relief. For an argument that Congress should apply the Fair Housing Act scheme to Title III of the ADA as well, see another text by Ruth Kolker, titled ADA Title III, A Fragile Compromise. And I was going to move right through to part 1 of the remedies section, standing and pleading requirements, but I'm actually going to read this section again in that recording, because this is incredibly relevant, talking about when monetary damages are going to be available and when they're not going to be available. And as a tricky concept, the professor said we need to know it. So I'm going to record that next. Thank you. Bye.